Okay, it's 1:03. We're going to get started. Hello, everybody. I'm Carlton Mays, and welcome to the 11th presentation of the QC webinar in the webinar series. I also wanted to give a big thank you and some gratitude to new subscribers that took advantage of our 30-day free trial period and then converted over to subscribers. Greatly appreciate it. Today's webinar will focus on separate property issues in a 401k plan and how to deal with them. Topics to be covered are separate property in a 401k account, how to identify separate property interest and the importance of figuring this out early in the divorce process, options for valuing the separate and community property interest, what the QDRO should look like, and why drafting clear judgment language is critical. You should be able to see our two expert speakers today, John Madden and Lorrina Duffy. John is a nationally known retirement benefit valuation expert in dividing marital and community property in divorce cases. Since 1999, John has been a recurrent expert witness for the courts on the subject of valuations and QDROs. He is also a frequent speaker on the subject, including for AAML, ADFP, and numerous bar associations. In addition to QDROCounsel, John is a co-owner of the consulting firm Moon, Schwartz, and Madden, and is a member of the QDROnes, a national study group comprised of QDRO attorneys and pension valuation experts. Lorrina is a nationally recognized QDRO expert with a diverse background in QDROs and family law. Lorrina is a recurrent family law court-appointed expert speaker on QDROs. She has practiced law since 2006, including as an attorney for the Legal Aid Foundation of Los Angeles. Lorrina is also the president of the Latina Lawyers Bar Association, which services include providing Latinas with a community of support, together with specific resources and tools to allow them to achieve their greatest potential, and provides law school scholarships. She is fluent in Spanish. Lorrina practices law with QDRO Benefits Law Group and is also a member of the QDROnes. Everybody, please know that your microphones are turned off, and if you have any questions during the presentation, use the Q&A function and post your question. Do not use the chat function. I will take stops throughout and we will address all questions. John and Lorrina, it's yours now.
Thank you.
Thank you, Carlton.
You're welcome.
So today our focus of our talk is on calculating the separate property interest in the defined contribution plan. I also added a discussion on calculating that for IRAs. And I'm going to share my screen, and I have my document set up, but it takes me a moment to, share screen. So give me 1 second, and I will share my screen, and we can get started. Okay. So this is us. The basics, get the plan name right. I always like to throw this in just because we have access on the platform to over 150,000 plan names. So you should always have the plan name right, because you should just do the search. Make sure you name the plan correctly in your judgment and any documents that's at your fingertips. I just like to always throw that in. Okay, so today the focus is on defined contribution plans. These are your 401ks, your profit sharing plans, money purchase pension plans, employee stock ownership plans, savings plans. Usually the name of, the title of the plan usually gives you an idea of what type of plan it is. So either contributions are made to the plan by the employee or the employer, so some sort of combination, matching, whatever it may be. And at any given time, you know how much money is in the plan because you receive either monthly or quarterly statements that reflects the actual plan balance, meaning it's going to show the contributions and how the account performed during that period. So it's going to show any investment earnings or losses, whatever applies based on how the participant is invested in the plan. And these are the four most common ways we divide a defined contribution plan. It's either a percentage or an amount as of a date specific or as of the date that the account is segregated. Date of account segregation is a future date whenever the quadro is implemented, so it's after it's filed and served on the plan, versus a date specific. It's usually a historical date, whether it's date of separation, date of judgment, or some sort of other valuation date. So it's either going to be an amount or a percentage based on one of those dates. Okay, so these are our questionnaires which are available on the platform. And, you know, you can, if you're doing just quadros, you can give this to your customers to fill out so you can understand what type of plan you're dividing. Or if you are a family law attorney and you're doing quadros as part of your practice, as part of your intake, you can just, you know, slip these into your intake package. And when I receive this, these are the main areas I look at. And so the first one is when the participant entered the plan. So if the participant entered the plan before date of marriage, then I know that there's a separate property interest. The separate property interest would be, you know, whatever balance existed on the plan as of that date of marriage, plus any investment earnings and losses on that balance. The second place I look at is number 8. Did the participant roll over separate property funds to this plan between date of marriage and date of division? So that means during the marriage, let's say the employee spouse had another plan from previous employment that was, you know, accrued prior to date of marriage, but they rolled it over to a new employer plan. So now it's, you know, mixed together. And then I also always look to see if there's a loan, number 9, if there's a loan in the plan. So for the rollover separate property interest, it would be whatever that balance was, that rollover balance, as of the date of the rollover, which is somewhere in the middle of the marriage, plus any growth on that.
Yeah, and the important thing with the questionnaires is, you know, these questions are designed so that it really jogs the memory of the client, right? Because a lot of times people will forget that perhaps they had rolled over a prior 401k plan. So it's just really designed to sort of trigger, you know, a red flag, if you will, that you do need to spend a little bit more time figuring these numbers out before you get to the quadro. And that's what these questionnaires are designed to do.
Especially if you have a client that's changed their employer every 2 years, it's likely that every time they switched employer, they took their 401k with them and they kept, you know, transferring it to the new employer sponsored, you know, 401k plan. Okay, so these are the 3 types of separate property interest we usually deal with, and I spoke a little bit about it, but I'm going to talk about it again because I'm going to introduce the third one. So that the first one is, did the participant contribute to the plan prior to date of marriage? Did the participant roll over the account balance of another defined contribution plan that is composed of separate property monies into the plan during the marriage? And this is the third one, which happens with some frequency, is the earliest division date under the plan after the marital division date? So the example being, if the parties, you know, separated January 1st, 2019, and the plan at that time was with Fidelity Investments, and then the record keeper switched to Schwab as of, let's say, May 5th, 2020. So now you have a gap where the employee contributed money and there was investment earnings, but the plan won't go back to January 1st, 2019. They will only calculate investment earnings from May 2020 forward. So now you have a separate property interest that you need to deal with. I think we have a question.
We have a question from
Yes.
Tony Williams, and let us know also if maybe you're covering this, you or John. What is the next step when they cannot answer some of the critical questions? I think it was when John was talking about the questionnaire.
So I'm going to get to that.
Okay.
On the options of how to calculate it. So I'll circle back to that one.
Okay.
I'll give you the, I don't have anything, what's the best thing I can do option. Okay. Okay. So the platform has the following calculators for calculating the separate property interest. They have the rate of return S&P bond values calculator, the marital fraction time roll calculator, and the simple tracing calculator. And John's going to step in right now to explain what we mean by S&P 500 bond values. since he, you know, created these calculators, he's the
Right.
right person to speak on them.
Yeah. So I guess I first would like to say that, you know, if the client does have all of the records, that QDROCounsel does offer what we call a simple tracing to go through each of those periodic statements to create a detailed spreadsheet. If those statements are not available, then you would say, okay, well, sort of a backup would be to look at the calculation suite and you know, decide which of these tools is the one that's going to be a best fit. So the S&P 500 rate of return, bond rate of return calculator really just is intended to provide a surrogate rate of return for what the actual account had earned. So again, as Lorrina will go through, you know, if you need to look at a date of marriage balance and grow that, because premarital separate property is not only the balance, but also the gains or losses on that balance. This S&P 500 bond value calculator can allows you to run various rates of return to come up with an approximate premarital separate property interest. So that's what that calculator is, a blend, and you can select, as I think Lorrina you will show later, you can select if you want 100% stocks, 0% bonds, you know, 80-20 all the way down to 0% stocks and 100% bonds. So we're just looking at, we're pulling the actual rates of return for the S&P 500, the S&P 500 total return, which is just including dividend reinvestments. And then we have our own investment grade composite bond index to use as well. So it's made to be very, very simple, as I think we'll show later, to come up with these rates of return as opposed to trying to do it all by hand.
Thank you, John. Okay. So I love these calculators. I spend most of my time on them when I'm on the platform. So the first one we're going to try out is the estimate rate of return, S&P option 1. And so what that signifies, this is exactly, you know, pages of the platform, and I'm going to walk through it with you, but I'm just going to explain what, you know, all the inputs are. Obviously, this is self-explanatory. The participant's name, alternate B's name, the name of the plan, date of marriage, date of division. Again, usually here in California, it's going to be your date of separation, but the parties may have agreed to a different marital division date. And then you choose your options, right? The first option is your separate property premarital interest in the plan. Second option is separate property funds rolled over during the marriage. And third option, separate property in the funds in the plan after date of division, which is the scenario where you know, there's been a change of record keepers. Okay, so we're going to go through option 1 first. And so each option, when you click on it, it's going to give you different questions, different inputs. So I'm going to review them for you, and then we'll do it together on the platform. So enter the total account balance as of the date of marriage. Enter the total account balance as of closest to the date of division, so your date of separation balance. And then, just like John said, you can manipulate this, and then you put in your email, and that is literally all you need to do, and a report is generated. So now we're going to do it together.
And while you're bringing that up, I'll mention that using this rate of return tool, if you don't have all of the statements really that you would need to do a more detailed tracing, you know, instantly you can probably think that the clients would automatically start arguing about which rate of return should be used as the surrogate rate. And the nice thing about this tool is that you can very easily just toggle the percentage, 50-50, 100% stocks, 0% bonds. You can run various reports within a few minutes, and then you can use that to show to the clients that perhaps the actual dollar amount that they're arguing is not so significant that you can find compromise quickly, which is what I have done for years to try to get people to reach settlement quickly without having to go to trial to argue about this stuff. So, I mean, that's a huge win, I think, with this tool to get people to you know, get over the hump, if you will. So go ahead.
Exactly. They'll be spending more money on attorney's fees arguing versus what the actual dollar amount. So from the member dashboard, you would go to the calculation suite. And then since we know what we're doing, we would choose this one. And then you have instructions here if you want to sort of more explanation of what documents you need or what information you need before you actually launch the tool. And we're going to go here. And if you've attended these events before, you know Keanu Reeves is my soulmate, so he's always my example. And then we would never separate, but for fun.
Illustration purposes only.
Okay, so the closest, the total account balance included any loan balance closest to the date of marriage. We're just going to say 10,000, and then we're going to make it really simple. And then you can manipulate it just like John said, depending, if you look at the statement, usually statements will show exactly how they're invested. So you can manipulate it. The default will always be 50 stocks, 50 bonds, 50% bonds, but you know, you have that option there. And then that's literally all you have to do. And a report will be generated and emailed to you literally within 2 minutes. And I'm going to show you what the report looks like. Give me 1 second as I'm sharing my screen. Sorry. Okay, so this is the report. And I ran this yesterday. And again, you get it within 2 minutes. And it's going to have the information, I input it, right, in terms of the plan. And then it's going to have the balance as of the valuation date. In this case was date of separation. The marital share is 89,000. The separate property interest is 10,000, and the alternate payees award would be 44,000 and change. And it has the dates right here. It shows that during that period that I put in, so you know, date of marriage to date of separation, there was an 8.73% rate of return for the percentage ratio of 50-50. So it's
right.
that easy, and that report is generated, and you can just share it with the parties in the letter. Super easy. Okay, then we're going to go back to the platform and do other calculations. And feel free to interrupt with questions.
I will say that, right, and the calculator that you know, I update routinely goes back to the early 80s and runs up to the most recent you know, data available. So I mean, you know, it's a dynamic program that we update frequently. It's not just, you know, set it once and forget it. And it, you know, for those of you that are interested, you know, it does incorporate dividends, stock splits, all of those things. So it's a total return, you know, and we do that update frequently. So it's nice to have that ability.
Okay, the second option is, again, same information that these questions you'll always have to answer. And then if you choose option 2, which again is separate property money rolled over into the plan during the marriage, these new questions are generated. Enter the amount of the separate property money that was rolled over, the balance as of your date of division, date of separation, and then you know, how you want it split, and then you enter your email and you are good to go. I'm going to go back and we'll do it together. As soon as I find it. Sorry, guys. Makes it exciting. Okay. If people are not finding it helpful for me to go through each calculation to, each time, you know, let me know. Give me some feedback, because sometimes people doing these calculations, it seems a little, I think when I first started doing them, maybe a little confusing, a little overwhelming. So I feel like it's useful to do them together, even though you think, oh, I got it. I still think it's helpful. But well, if you disagree.
John, while Lorrina's doing this, I was curious, the statistics you were talking about and the constant updating, Are those national, or are they state, or are they a combination of that, the updating to the statistics?
For what's behind the sort of behind this calculator?
Yeah, when you're looking at bond and rates and
Oh, okay.
cost of living, et cetera.
Right. Well, for this particular calculator, we're pulling directly from, you know, the markets. So I mean, we're looking at, if we were to update it through yesterday, you know, we would be looking at the actual S&P 500 from 1980 through yesterday, you know, and then all the other indexes that we have in there. So we're pulling real data and updating them behind the scenes, and then that way it's just seamless in terms of running the calculation like Lorraine is doing now.
So this is option 2, and so each time it's going to be slightly different, right? Because we're doing different things. In this case, I said that in January 1st, 2019, we were married in September 17, 2018. January 1st, 2019, the participant rolled over $10,000, and so they should get that separate property interest of $10,000 plus any investment earnings and losses from January 1st, 2019 to the date of division, August 31st, 2020. We see the assumed rate of return is 16%. And so that makes the separate property interest 11,000, alternate pay shares 44,000. And that's how that one's done. And then we have a question. John, do you want to take that one?
Yeah.
How is the stock bond percentage derived, 50-50 versus all the other?
So the, I mean, the percentage is the percentage, the ratio, I should say, is based on the drop-down menu, whether it's 50-50, which is 50% stocks, 50% bonds, 80% stocks, 20% bonds. But the blend of the S&P and the S&P 500 total returns is a 50-50 blend, and the blend of the 3 investment grade bond indexes. So we've created our own composite bond index, which has 3 bond indexes within it. And that's an equal blend of those 3 bond indexes. So we're taking all the stock indexes, the bond indexes, and then depending on what you've entered into the platform, we'll use that ratio to come up with the final total return. I hope that answered the question.
Okay. So this is the one, this option is when you have the earliest division date is after the date of separation. And let me know if this is clear, what the scenario I'm discussing, where we know that at date of separation there was $100,000 in the account, but the plan won't go back to the date of separation. They won't go back to January 1st. In this case, January 1st, 2019 is my date of division, my date of separation. But the earliest date the plan will calculate investment earnings and losses is August 31st, 2020. And because there's been separate property monies contributed after that date, you need to figure out that separate property interest, that gap between January 2019 and August 2020. And so here you can see that during that brief amount of time between January 2019 and August 2020, 16.9%. And it shows you the separate property interest is 8,000, alternate pay shares 58,000. And again, generated within minutes to your email box. And then we have a question. Does it happen a lot that have to calculate earnings after data separation? And actually this scenario is very common because 401k types of plans change custodians with some regularity. You know, I don't know, what would you say, John, it happens maybe every 4 to 8 years that they change custodians?
Yeah, so I mean, you definitely see a lot of change of custodians. You know, and I know I've talked about this in other webinars, but you know, I would also just recommend if the data separation is not that many years ago, but say a few years ago, getting the statements is certainly a realistic expectation, you know, that they exist and you should be able to get them.
Oh, you froze.
Yes.
We have a question also. I'll see if, I'll ask it if John comes back on. John, you there?
Yeah, he's on mute, but he's
Okay.
there. I can see him.
Yeah.
Oh, there he goes.
Okay.
John, you can hear us?
Yes, yeah. That was weird. I don't know what happened.
Hey, John, we have a question also.
Go ahead.
If you don't have all the docs from the plan, rollovers, et cetera, how do you know mixture of equity and stock parties may have?
Well, in order to use the rate of return tool, you are going to need to have, again, if you say you're using option 1, which is a premarital interest. So in order to use the rate of return tool, you're going to have a date of marriage balance. So you would have to have some kind of statement that would hopefully indicate the type of investments that were held at the time of marriage. If you don't have the date of marriage statement, then presumably you would not have a date of marriage balance. And there's still, and Lorraine is going to get into that next, so it's kind of a good segue. But if you don't have a statement at the time of marriage, but there isn't a dispute as to there being a premarital separate property interest, then the next probably best tool would be the time rule calculator, which is what we're going to get into now. So there are times where you may not have enough information to use the rate of return tool, at least for option 1. But now we have another tool that does the same, you know, it gets you to the end goal, really. So Lorrina, if you want to talk about the time rule.
Yes, I would, John. So I'm sure everyone's familiar with the time rule formula. Date of marriage to date of separation divided by the employee's entire time with the plan. But just remember, because I see sometimes when people do these calculations, they get them wrong. So I just want to spend some time explaining how the time rule formula would work for a defined contribution plan. So the first thing is that the denominator, you know, wouldn't be, it would be, you know, date of plan entry through date of separation if they're still contributing, or if they stopped contributing earlier than that, it would be that date. Or if the earliest division date is after date of separation, it would be that date. So you just got to be careful that when you think of the time rule formula for a defined contribution, that you have to just not be on, you know, what's it called when you're cruise control, or you're not paying attention to, yeah, autopilot, thank you. Make sure you're using the right dates, because I've seen it and I've talked to a lot of people when they run their own little time rule formula, they're using the wrong dates. Also in the numerator, it's usually date of marriage and date of separation. But if the participant didn't start contributing to the plan until after date of marriage, you would use that date and not the date of marriage, because otherwise you're messing up the time rule formula and the division isn't equitable at that point because it's incorrect. And so what we were talking about earlier is like, what would you do if there's no documents, there's no information, but it's undisputed that you know, there's a community and separate property interest in the plan. So when there's no other option because the parties were married a very long time ago, there's no statements, or for whatever reason, but you want to give the participant credit for the separate property interest, this is pretty much your only option, unless the parties are going to agree to an amount that existed at the time. So this is what we usually do when we have no other choice. And we want to give the participant the benefit of his or her separate property interest. Okay, we're going to launch it. Okay, usual same information as always, right? But each one is going to ask you this. Date of division would be 8/31/2020. I'm using the same dates each time, but playing them around with them. So let's say the date of plan entry is January 1st, 2015. And will the plan calculate investment earnings? This time we're going to say yes. The next one I'll say no. And do you have the account balance? You don't need it, so we'll make it easy. And then it will email it to me. really convenient. And let me share with you what it's going to look like. Give me 1 second. Okay, so this is what it's going to look like, and it's going to have your valuation date, your date of marriage, your date of division, and also the date of plan entry. And it's going to show that the plan is 34% community property, and the alternate payee shares only 17.25%, so half of that. And again, the time row formula, as you know, is, obviously in the title, is just based on time. So it doesn't take into account the fact that although maybe contributions made earlier in the marriage or earlier, when the participants still started contributing, are lesser in amount, but they've had more time to increase, to accrue investment earnings and losses. And although maybe contributions later, closer to separation, are larger, they have a less amount of time to accrue investment earnings and losses. It doesn't take any of that into account. It's just simply time-based. But if you have no other option, and the parties can agree, and there's no documents, and you want to agree on something, this is what we would use for a defined contribution plan. Oftentimes I see in judgment they're using the time row formula for a defined contribution plan, but again, I wouldn't advise to use this plan unless you had no other option, just because again, it's just based on time. So it's not always the most equitable way to divide the plan, but sometimes may be the only option for you. And then I'm going to show you instead of working through the same report, I feel like I can't get a feel if that's helpful or not. I don't see anyone. I'm just going to show you the second report as soon as I find it. Okay, so this is the second one where the dates are slightly different because the earliest division date under the plan is 12/31/2020. So then the numerator would be, date of marriage 9/17/2018 to August 31st, 2020, date of marriage, date of separation. But the denominator would be January 1st, 2015 till December 31st, 2020. And for this one, it only has the two options for the time row calculator.
And I would say in terms of sort of the order of how you should approach a defined contribution plan would be certainly if you can get all of the records, then you can contact QDROCounsel for what we call a simple tracing, and that's where you get a long detailed spreadsheet back to you. But if you don't have those records, then that's where these estimation tools come into play.
And so, as always, even though we're dealing with the separate property interest, you still want to ask questions such as, is there a loan? And you want to know when the loan was taken. The presumption is that a loan taken during the marital period during the community is a debt of the community. But the presumption can be rebutted. But you definitely do want to know, because usually if the QDRO, not usually, but always when the QDRO is a percentage, you're going to have to specify whether the loan balance will be included or excluded. Usually when it's a dollar amount, you don't have to have that language, but some custodians do require it. So to review, I know we've discussed this before in previous sessions, so it's review for some or maybe new for others. And it's very counterintuitive. To exclude the value of the loan means the participant's account balance on the date of division is reduced by the value of any outstanding loans. So in essence, the alternate payee is receiving less money, representing them repaying their share of the loan. By including the value of the loan, the participant account balance on the date of division is not reduced. So the alternate payee is receiving 50% of the account as if there was no loan. So the example would be if you include the loan and there's $15,000 in the account with a $5,000 loan, the alternate payee is getting 50% of $15,000. But if you exclude it, it's 50% of $10,000. Again, the loan is always the participant's responsibility. So that loan is always going to be $5,000 that the alternate payee has to pay back. But the alternate payee is receiving either less based on them paying half of the loan, or as if there is no loan by including it. And then investment earnings and losses. So as you, I'm sorry, I'm looking at the question. Can you show us side by side of what calculation of benefits would be under each method using same numbers? Not on, probably not on the spot. I don't know if I can show those screens at the same time. I don't know if John, you can do it.
Yeah, I was going to say we probably aren't ready to be able to illustrate that particular question. I mean, it's a great question, you know, and I will say that, you know, in terms of doing a simple tracing versus a rate of return estimate versus a time rule estimate, you know, I have done some side-by-sides in the past. Typically, the fact pattern is, you know, I ask for all of the statements. They don't either, you know, generally they don't feel like taking the time to gather all the statements. So then we run estimates in which they're not comfortable with. They provide all the statements. And then we say, okay, well, here's the direct, you know, the simple tracing versus the prior estimates. And, you know, as long as the participant has been contributing just normal, you know, payroll deductions from start to finish, you know, you will see that the simple tracing versus the rate of return versus the time rule gets you very close to the same number. The points where, you know, you'll want to just be mindful of, which, you know, the QDROCounsel reports disclose, is if there was, you know, a big loan or something like that, or a distribution that the statements would reveal, but, you know, using one of these estimate tools, you know, that's still a safety net, because if the numbers come out, you know, somewhat odd, then that's a trigger to say, okay, something must have happened. So, but yeah, doing that side by side, I've done a few times over the years, and it's nice to see that these estimation tools get you pretty close to what the simple tracing would give you had you know, had all of the records.
Thank you, John. But maybe next time we do this presentation, we'll include that, because that's a good idea. So thank you, Christina. So investment earnings and losses, I would hate for you guys to use these calculators and then draft your judgment and not be clear on whether investment earnings and losses are included. So under California Community Property Law, the division of a defined contribution plan includes investment earnings and losses from date of separation to date of distribution. So, you know, the alternate payees, community property interest, it includes their share of the benefits as enhanced. I always like to throw that in. So, you know, once you do calculate it and you calculate, okay, I use the calculator, the separate property interest is this, the community property interest is this as of this date. Don't forget to add the additional language. Alternate PE is going to get $10,000 as of this date, excluding or including whatever the parties agree to. But if, you know, usually it should be including investment earnings and losses. And, you know, importantly, say what date you're using. You know, it seems like this would be simple, but I mean, I've worked on judgments where I've given the exact language and been very clear, say the date and also say whether investment earnings are included, and then they don't listen to me. And then it becomes a problem later because one attorney had one thing in mind, another party had another thing in mind. Just make it clear in your judgment and avoid yourself, you know, heartache. Okay, so today's focus was on defined contribution plans, but I thought I would, you know, include individual retirement account plans. So IRAs do not necessarily require a qualified domestic relations order. Depending on the IRA custodian, you can divide the IRA with division language in the judgment. You just want to make sure that judgment as to status is entered, whether that's legal separation or dissolution of marriage. And if more information is required than what is in the judgment, then a 408 order can be prepared, and that, you know, you can do those things on the platform. The thing with IRAs is that they can only be divided with a percentage or an amount as of date of implementation. And the date of implementation is a future date once the IRA is actually being divided by the custodian. So if you do a 408 order, it's not going to happen until the order is signed, filed with the court, and then served on the custodian. So there's no historical division. So if you're writing judgment language and it says, you know, each party is entitled to 50% as a date of separation plus investment earnings and losses, that's not going to work. So no historical division dates for IRAs.
Yeah, that is a fundamental difference with a IRA custodian versus a QDRO administrator, you know, or QDRO custodian. is that you even though it seems like you should be able to say X dollars or percent as of some past date adjusted by gains or losses, the IRA custodian will not make that calculation. And I think, we've all gotten so used to 401k administrators doing it that it's become very clear to us that this is very important, because you have to not only say as of the date of transfer, but then you also have to make sure that, the person that holds the IRA stops contributing or, removing funds until that transfer can be complete.
So just like other, just like similar issues with the 401k, you want to know if the participant contributed to the money, contributed to the IRA before date of marriage, rolled over a balance, or contributed to the plan after date of separation, or took a withdrawal after date of separation. Because all those issues would need to be resolved prior to dividing the IRA. You don't want to divide the IRA equally. It's 100% community property, but the participant took out a withdrawal after date of separation, and it was a separate property withdrawal. So it wouldn't be fair to equally divide that IRA. Either you're going to have to, use one of these calculators to see what's fair, or, change the percentage. And that's what these calculators do. And there's similar options under, just like the 401k. I won't go through it, but I did calculate a few of them just so you can see how they look different. And I'm going to share. I won't run through it again because I don't know if that's being helpful. I'm not getting any feedback. So I'm just going to show you the reports. Okay, so this is what the report would look like. So the date of marriage is the same, 9/17/2018, date of valuations 8/31/2020, and then it shows that there's a separate property interest of 10,000. So for this one, it says valuation date 8/31/2020, but as we just discussed, IRAs can only be divided as a date of implementation. So you would draft the IRA order for 44.56%. So you want to make sure that after 8/31/2020, which is the date of separation for this hypo, you want to make sure that there's been no new contributions or withdrawals as of that date. Because if there have been, that percentage will not be accurate. Does that make sense? That's a sort of an extra, a few extra questions you're going to have to ask about IRAs. Otherwise, the percentage will be off. Let me show you the second one. Do you guys want me to run through the calculator or not really? I don't see any feedback. Okay, so here's the second one. Again, this is when, for the second, where there was a rollover. So we know that as of date of separation, there was 1,000. There was 1,000, and we know that that was the balance as of date of separation, but then there was a contribution or a rollover, and it takes that into account. A rollover happened January 1st, 2019 of 10,000, and it attributes that with 11,000 as of date of separation, with 88,000 being community, and that's the percentage. And that percentage would be good as long as there's no contributions or withdrawals after August 31st, 2020. Let's see, we have a question. How do you account for separate property contributions to IRAs after date of separation? You want to take that one, John?
Yeah. So basically, if there's been any contributions or distributions since separation in an IRA, and this really applies to 401k plans and other defined contribution plans as well. But ideally, the best way to handle it and the most accurate is to get the statements and contact QDROCounsel for your simple tracing, which is a detailed spreadsheet that's going to show the money coming in, the money going out, and it's going to bring that up to date as current as possible. And then that's where you're going to want to make sure that, the participant stops contributing or stops taking distributions from the account until such time as you can get the IRA, 408 order in place. And then the money gets transferred over and then you're okay. So really, ideally, the best way to do it is to get the records. If not, then you can use the estimation tools. Say if you had a date of separation balance, you could grow that by a rate of return through a current date, and then again tell the participant to to hold off on adding or removing any funds. But ideally, with the market volatility, CARES Act distributions, everything that's happened this year, I think getting the records is absolutely best practice. And then you just get your spreadsheet put together.
Okay, I have another question. These reports are so easy to read. In your opinion, are most clients satisfied using these estimation reports, and are you able to settle the separate property issue? This seems to come up a lot. And it does come up a lot. It's a very common issue, again, because of a change of custodians. Also, parties do contribute to IRAs after date of separation, around tax time. But usually, I would say the vast majority of people don't have their statements, especially if the date of separation was a long time ago, or they're not able to get the statements, or, discovery's over and one party is not cooperating, or whatever it may be. But I use the S&P to settle separate property issues with very high frequency. I don't know what do you say, John?
Yeah, I mean, as being the guy that usually ends up having to go to court to testify to all this stuff, I have seen a significant increase in the amount of settlements, which obviously is great because it saves the clients a lot of money and hiring experts to come to court and everything. So I mean, using this rate of return tool to say, people can argue all day long about using an 80-20 blend of stocks and bonds where the other person maybe wants, a 40-60 blend. And at the end of the day, it takes 5 minutes to run or less, the two reports. And you can show the clients like, look, you guys are arguing about $5,000, which, if we take this to court, you're going to spend that easily, so just split the difference or whatever works, So yes, I absolutely think that this tool really, I think improves the whole process of figuring this stuff out to reach settlement and move on to the quadro, which is really the point.
John, we have another question also. How much more expensive is it to request simple tracing versus using the calculator when you quote the costs?
Well, I mean, that's a great question. And if you can get the records, I mean, I've had cases where, the administrator allowed an award date from 20 years ago, and they would do the calculation. So the parties don't know what the numbers are going to be until after the quadro's, taken effect. Whereas if those statements were available, and sometimes they are, maybe it cost $1,500 to trace 20 years of statements. But in that case, what happened was the custodian had made an error to the tune of $100,000 to the alternate payee. So I mean, if they hadn't asked me to go back and review the plan's calculations, it would have been $100,000 error. Whereas if they'd done the simple tracing and spent $1,000, then they would have had a number as of 2020. And that's what would have been used in the quadro. So I mean, again, it's not that expensive really to do a simple tracing. A few $100s usually. If you go back 10 years, maybe it'll cost $500 or something to do a simple tracing. But considering all of the risk in terms of the plan doing it correctly, if they can even go back that far, then you get a rejected quadro and you have to fix it. So I mean, if you can get the records, that's absolutely the way to go. And I don't think the cost, I think it's minuscule compared to the risk that you're taking by not knowing until after the money's been separated.
Let me read you these questions. If the 401k was issued by a company that has been bought out by another company and uses Fidelity to manage the 401k, is a subpoena to Fidelity the best way to obtain 7 years of statements? Does Fidelity typically limit document production to 7 years, or would they be likely to have moved to file? And then there's a follow-up. Or is it better to just have the client retain your services and make it your problem to figure out the community interest? What does that cost? And do you then do the subpoenas instead? It's kind of long.
Yeah, well, Lorrina, do you want to maybe address the part of, taking responsibility for discovery and all that stuff? And
Yeah, so we don't do discovery. We leave it up to you guys, the family law attorneys, to do discovery. And it's sorry, you raised the question, but was she asking about 7 years?
The part about obtaining the statements. I mean, so Fidelity is only going to be able to go back as far as they do have records. So if they took over 5 years ago, they're only going to be able to give you 5 years. If they took over 9 years ago, they might still have 9 years, but they're only legally required to have 7. So it really just depends, on when Fidelity took over. And they will, if the data separation was 7 years ago and they took over 5 years ago, they're going to reject the quadro and say, we need a date as of 5 years ago or sooner. And then it's on you to figure out what to do. And if the records are there, then you do the quick tracing for a few $100. And if the records aren't there, then you fall back on one of the estimation tools.
Okay, sorry, it's slowed down. So for the division of an IRA, if you are gonna actually end up doing, dividing the IRA with judgment language, again, you have to be specific in your judgment. You want to include the name of the custodian, the last 4 digits of the IRA account number, and again, clear award of either a percentage or a dollar amount. It would be a shame to actually calculate everything and then have your judgment not be sufficient to divide the IRA because it wasn't with enough specificity that it was rejected by the custodian. And again, if you have any questions, any concerns, or you don't know, or you're not sure if you did something correctly, or whatever it may be, you can always request support, and we're there to help you. I thought I saw another question.
No.
Okay, that's all I have. I don't know if you want to add anything, if anyone has any more questions. I hope you guys found this helpful. John, I don't know if you want to add anything.
Thank you for having us.
I really enjoy using these calculators. And again, as the most important thing is when you guys are negotiating and trying to figure out what makes the most sense in your case, you can run these different calculations, make offers, split the difference, whatever it may be. Because I know in my years of, doing quadros, parties are literally fighting over, sometimes $2,000, and they've just spent, $5,000 on their attorneys fighting over those $2,000. So it just doesn't make sense.
Yeah, I think that's one of the biggest attributes to the calculation suite is I think it now empowers attorneys to use that to try to quantify what, the clients are arguing over, right? It helps you put a value on some of these retirement plan issues. So really, what dollar amount are we arguing about here? And is it worth it? So I think that's one of the biggest pluses to the calculation suite is providing that as a tool.
Well, thank you both. And for attendees, if you do have any additional questions or you want to take any deep dives into any part of the program, please reach out to us at QDROCounsel.com. You also would have noticed on your invitations, because I'm sure you've all seen it, we still have 3 more monthly webinars coming up on the last Friday of each month at 1 o'clock. We hope you join us. And if you have any questions about pricing, we have monthly and annual and multi-year subscriptions available. And in addition, anybody who's attended today, you're welcome to a 30-day free trial with unlimited use, access, and deliverables of the platform. And that's, I think, a good way to get your hands dirty with this, especially with the calculation suite. So if we don't have any further questions, you'll see in the chat room that Araceli posted contact and follow-up information and links. And we thank John and Lorena for leading it today and for all of you attending, and be safe and have a good weekend, good afternoon.